True crime, John Warren, the missing Oldsmobile, and long mystery. The Holiday Inn, the missing Oldsmobile, and the evidence trail across 3 states. Content note: this article discusses a serious criminal case and includes restrained references to violence and legal evidence. A hotel room beside Interstate 75 is built for passing through. In October 1985, John Christopher Warren was not in Middletown, Ohio, to become part of a criminal file. He was there for work. He was a traveling auto parts salesman from Dalton, Georgia, staying at a Holiday Inn near the highway while attending sales meetings. The room was meant to be temporary, one stop in the ordinary geography of a man whose job required roads, receipts, schedules, and luggage. Then the map changed. A car that should have been parked nearby was gone. Personal belongings that should have stayed with their owner had vanished. What began as a local hotel room investigation soon stretched south, first to Georgia, then to Florida, leaving investigators with 3 scenes and not enough proof to carry the case into court. For decades, that was the shape of the Warren case: a room, a missing Oldsmobile, recovered property, old leads, and a silence that outlasted the first investigators who worked it. The question was not only what happened in the room, it was whether anything left behind could still speak clearly enough after 40 years. This article follows the case through the latest confirmed legal developments as of July 9, 2026. The life before the case. The public record gives John Warren less personal detail than many modern true crime readers expect. That absence matters. It means the article has to treat the known facts carefully, rather than invent the private shape of his life to make the story feel fuller. What is known is concrete. Warren was 44 years old. He was from Dalton, Georgia. He worked as a traveling salesman for an auto parts company, a job that placed him on the road and, in October 1985, brought him to Middletown for sales meetings. That kind of work has its own rhythm. The road becomes routine. Hotels become temporary offices. A car is not just transport. It is storage, schedule, independence, and return route. Warren's 1985 Oldsmobile mattered because it belonged to that normal working life before it became part of the investigation. Public reporting has not given the full shape of Warren's private life. That should not make him feel less real. It means the available record now presents him through work, travel, property, evidence, court filings, and what prosecutors say happened after he checked into a hotel room that should have been uneventful. The people around him. The early public file is not rich with a supporting cast. There is no detailed public account of a complicated domestic background, a known personal dispute, or a dramatic pre-existing conflict. That is important because it keeps the case from drifting into unsupported motive. The people who matter most in the current record are not introduced through intimate biography. They enter through official roles, hotel staff, or responders who became aware something was wrong, law enforcement officers who processed the scene, Dalton police who later recovered property, Warren County investigators who kept the case alive, and prosecutors who eventually took the file to a grand jury. The alleged accused person enters much later in the public chronology. As of July 2026, Randy Lane McAllister, 62, of Columbus, Ohio, is charged with aggravated murder and murder. He has pleaded not guilty. That posture controls every responsible sentence about him. He is accused, not convicted. There is also an alleged accomplice, described by prosecutors as now deceased. Authorities have not publicly identified that person in the sources reviewed for this article. That limit matters. A name missing from the public file cannot be replaced with speculation. The first cracks. The first crack was practical. Warren had checked into the Holiday Inn in Middletown on October 16, 1985. The hotel was near Interstate 75, a location that made sense for a traveling salesman moving through the region for meetings. At that point, nothing in the public record suggests the room looked like anything more than a temporary stop. The next day, the room was no longer just a room. Warren was found deceased inside it, and investigators noted that personal items were missing. His 1985 Oldsmobile was also gone. The absence of the car was more than a theft detail. It changed the geography of the case. A hotel room death might have remained physically contained, but a missing vehicle made the scene mobile. It created a route. It suggested that whoever took property from the room could have moved far beyond Middletown before investigators understood the full shape of the case. That early picture gave detectives one obvious working theory: robbery. But a theory is not proof. And in 1985, the question was not only whether property had been taken. It was whether the evidence could identify who had taken it, who had been in the room, and who could legally be held responsible. The last ordinary movements. The last ordinary sequence is brief because the public record is brief. On October 16, 1985, Warren was a guest at the Holiday Inn near I-75 in Middletown. He was in town for sales meetings, connected to his work as an auto parts salesman. The next morning, he was found deceased in his room. Those points, the confirmed frame. What happened inside the room between check-in and discovery is now the heart of the criminal allegation, but the public file does not give a minute-by-minute reconstruction. There is no reliable open record showing an exact entry time, a recorded confrontation, or a witness who saw the central event unfold. That limitation should not be treated as weakness in the story. It is the story. For 40 years, the gap between the room and the later recovery of property was wide enough to keep the case from prosecution. The last ordinary detail was the business trip itself. A man staying near the highway because work had brought him there. After that, the case stopped being about travel and became about what could be recovered from the trail left behind. The first alarm. When investigators entered the case, the room gave them two immediate categories of fact. First, Warren was dead. Second, property was missing. Prosecutors in later reporting state that his personal belongings and his 1985 Oldsmobile were taken. The room did not hand investigators a public suspect. It did not produce a solved case in its first hours. It produced a death scene, missing property, and a car that had left the local area. Then, the geography widened. Within days, police in Dalton, Georgia, recovered some of Warren's belongings and other relevant items discarded behind a Cracker Barrel restaurant. Warren's car was later located in Redington Beach, Florida. That sequence created a striking evidentiary shape: Ohio, Georgia, Florida. The distance made the case memorable, but distance alone does not prove identity. A car can move. Property can be transferred. Items can be discarded by people whose precise roles are unclear. In 1985, investigators had leads, but prosecutors later said there was not enough evidence to move forward. The first alarm had become a long problem. Evidence existed, but not yet in a form strong enough to answer the legal question. The search for an explanation. The first explanation was robbery, because the scene pointed that way. Warren's belongings were gone. The Oldsmobile was gone. Items later appeared behind a restaurant, hundreds of miles away, while the car surfaced even farther south. Prosecutors now allege the killing occurred during a robbery, and one summary of the indictment says McAllister is accused of causing Warren's death while committing or attempting to commit aggravated robbery. But the difference between an investigative theory and a courtroom charge is the central discipline of this case. Detectives can believe a robbery occurred. They can follow property. They can interview leads. They can suspect a route. None of that automatically identifies a defendant beyond the threshold required for prosecution. Authorities said detectives followed a number of leads at the time. Those leads did not create enough evidence to move forward. The file therefore entered the cold case category, not because nothing existed, but because what existed could not yet carry the case. That is what many casual summaries miss. A cold case is not always an empty file. Sometimes it is a file with fragments that do not yet connect strongly enough. The Warren case waited in that condition for decades. The evidence that did not fit. The evidence trail was unusually scattered. There was the hotel room in Middletown. There were belongings found behind the Cracker Barrel in Dalton. There was the Oldsmobile recovered in Reddington Beach. Prosecutors say items from all three scenes were eventually submitted for crime lab analysis after Warren County Sheriff's detectives reopened or re-examined the case in 2019. That step changed the case's center of gravity. In 1985, the question was what investigators could do with the techniques and proof available then. In 2019, the question became whether the old evidence still had biological, physical, or trace value that modern testing could read. Authorities have not publicly disclosed the exact forensic mechanism that connected McAllister to the case. That limitation is critical. It would be irresponsible to claim DNA, fingerprints, or a particular trace result unless the public record clearly says so. Some coverage has described modern forensic testing broadly. The prosecutor's publicly summarized position is that crime lab analysis of recovered items helped identify McAllister and a now-deceased alleged accomplice as potential suspects. That evidence did not instantly become a public trial record. Detectives continued investigating in coordination with the prosecutor's office before the matter was presented to a grand jury at the end of June 2026. The case narrowed slowly, not with one publicly disclosed cinematic reveal, but through old items being re-examined under newer conditions. The room had not changed. The road had not changed. What changed was what the evidence might be able to say. The event at the center of the case. The central event must be reconstructed carefully because the case is active. Prosecutors allege that Warren was killed during a robbery. At McAllister's first court appearance, an assistant prosecutor said Warren was beaten and strangled, and described the case as involving extreme violence. The same hearing included allegations that property belonging to Warren and the hotel was taken, and that McAllister left in Warren's vehicle. McAllister has pleaded not guilty. That is the prosecution's allegation, not a conviction. A jury has not yet tested it. The defense has not yet presented a full trial case in the open record reviewed here. The legal system has moved from investigation to accusation, but it has not moved from accusation to verdict. The known scene still has powerful limits. The public record does not show exactly how entry into the room occurred. It does not identify a public eyewitness to the central attack. It does not disclose the full lab results. It does not explain precisely how the evidence from Ohio, Georgia, and Florida is said to connect to McAllister. What it does show is a prosecution theory built around robbery, violence, stolen property, and a route away from Middletown. The hotel room supplied the starting point. The missing Oldsmobile supplied movement. The property recovered in Georgia supplied another location. The car in Florida supplied a further endpoint. In a circumstantial case, those locations matter because they may align into a pattern. But a pattern still needs proof. It must connect a person to the acts alleged, not merely create a dramatic map. That is the legal pressure, now sitting inside a case that spent 40 years waiting for a courtroom. When the story broke open, the story widened in July 2026 because the old file finally produced a charge. A Warren County grand jury indicted Randy Lane McAllister on aggravated murder and murder charges. He was arraigned in Warren County Common Pleas Court and pleaded not guilty. His bond was set at $500,000 after prosecutors asked for a higher amount and the defense requested a lower one. That court appearance changed the public posture of the case. Until then, Warren's death was a historic cold case. After indictment, it became an active criminal prosecution. The details released at the hearing also gave the public a clearer, though still incomplete, view of the state's theory. Prosecutors said Warren had been beaten and strangled. They cited alleged theft of property. They also referred to McAllister's prior violent felony convictions when arguing bond. Judge Robert Peeler set bond at $500,000. One report noted that he also recognized McAllister had lived a law-abiding life for more than 35 years, while still treating the current charges as serious. That detail is legally important, because bond is not a verdict. It is a pretrial decision, about release conditions and risk. It does not decide whether McAllister committed the crime. It decides how the case moves while the court process continues. The public story could no longer be contained by the phrase, cold case. It had become a live question in a courtroom. The case built from fragments. The Warren case is now built from fragments separated by time and distance. The strongest public strands are straightforward. Warren was in Middletown for work. He was found dead in his hotel room. Property and a car were missing. Some belongings were recovered behind a Cracker Barrel in Dalton. The car was found in Reddington Beach. Investigators re-examined evidence from all three scenes. McAllister and a now-deceased alleged accomplice were identified as potential suspects. A grand jury returned charges. The limits are just as important. The precise forensic connection has not been publicly detailed. The alleged accomplice has not been publicly named in the sources reviewed. McAllister has denied guilt through his not guilty plea. No trial verdict has been reached. The jury, if the case reaches trial, will not be asked whether the map looks suspicious. It will be asked whether the prosecution has proved the charges beyond a reasonable doubt. That requires more than the emotional force of a 40-year wait. This is where cold cases are often misunderstood. Time can make a case feel morally settled in the public mind, especially when an arrest finally comes. But time does not reduce the burden of proof. It often makes the burden harder, because witnesses age, memories fade, records thin, and forensic interpretation may have to do more work. The prosecution says the fragments now align. The defense has not yet had its full public trial opportunity to test that claim. The case is finally moving, but it has not finished. The outcome that did not end the story. As of July 9, 2026, the legal outcome is not a conviction, acquittal, plea, or sentence. The current confirmed posture is that McAllister has been indicted on aggravated murder and murder charges in connection with Warren's 1985 death, has pleaded not guilty, and is being held on a $500,000 bond. If convicted of aggravated murder, he faces the possibility of life imprisonment under Ohio law. That is the responsible stopping point. The case has an official accusation. It does not yet have an official finding of guilt. The distinction matters because cold case solved is easy language, but it is not precise language for an active prosecution. Investigators may believe they have solved the case. Prosecutors may believe the evidence supports the charges. A grand jury may have found probable cause to indict. None of those steps is the same as a trial verdict. For Warren's case, the indictment still represents a major legal turn. It means the file crossed a threshold it could not cross in 1985. But the story that follows belongs to the court process, not to public shorthand. The room, the car, and the recovered property have carried the case this far. Whether they can carry it through trial remains the unresolved question. The aftermath, people still argue about. The most obvious argument is about time. More than 40 years passed between Warren's death and the July 2026 court proceedings. Prosecutors have framed that delay as part of what makes cold cases difficult. Leads diminish, proof may be incomplete, and earlier evidence may point toward someone without being strong enough to charge. That explanation is practical, not sentimental. It helps explain why old cases can look obvious from the outside, but remain legally immovable inside a prosecutor's office. A suspect name is not enough. A theory is not enough. A trail is not enough. The state needs admissible evidence that can survive challenge. The second argument is about forensic science. Modern testing can reopen old files, but it should not be treated as magic. It can reveal associations, identities, contact, mixtures, or traces, depending on the material and method. It does not automatically reconstruct private events, explain intent, or remove every doubt. The third argument is about public language. If a case is called solved too early, the word can outrun the court. That risk is especially sharp here because the defendant is alive, charged, and pleading not guilty. Legal restraint is not a technicality. It is the difference between reporting an accusation and declaring a result. The Warren case now sits at that intersection. Old evidence, new charges, and a public hunger for finality that the court has not yet supplied. The review, appeal, or unanswered question. There is no appeal to explain yet, because there is no conviction. The unresolved question is narrower and more immediate. What exactly did the retested evidence show, and how will prosecutors connect it to the charges in court? The open record says items from the hotel room, the vehicle, and the Cracker Barrel location were submitted for analysis. It says that analysis helped identify Mac Allister and a now deceased alleged accomplice as potential suspects. It does not publicly disclose the full scientific pathway from item to suspect. That missing detail will matter. If the case proceeds, the court may have to evaluate chain of custody, forensic reliability, how the evidence was preserved, whether any testing result is direct or circumstantial, and what alternative explanations the defense raises. A cold case prosecution is often strongest when old evidence, new testing, and independent timeline facts reinforce one another. It is weaker when a single old item is asked to do too much. At this stage, the public does not yet know which kind of case prosecutors will present. The uncomfortable lesson is that an indictment can answer one question while opening another. It can answer whether the state now believes it has enough evidence to charge. It cannot, by itself, answer whether the state can prove the case. Why this case still matters? The John Warren case matters because it shows how ordinary travel can become evidence. A hotel room near I-75. A 1985 Oldsmobile. Belongings discarded behind a restaurant in Georgia. A car located on the Florida Gulf Coast. For decades, those details formed a route without a courtroom ending. In 2026, they became part of an active prosecution. The case also matters because it forces a careful distinction between investigative closure and legal closure. Families, police, and the public often use solved to mean a suspect has been identified. Courts require more. They require proof tested under rules, challenged by defense counsel, and decided by a judge or jury. For Warren, the available human detail remains limited, but the basic interruption is clear. He was a working man on a business trip, staying in a room designed for departure. The room became a crime scene. The car became a trail. The evidence became a question that waited decades to be asked in court. The final meaning of the case is not yet written. For now, the strongest closing image is still the road. Not the road that took Warren to Middletown, but the one the evidence had to travel before the law could begin again.